From the tearful reaction of this officer during the reading of his 36 counts during trial.
Count 11, rape in the first degree. Defendant is guilty of the crime of rape in the first degree and punishment is set at 30 years.
To the reaction of this former Inkster cop during his sentencing for a brutality case.
You're prohibited from possessing firearms, ammunition, or explosives for the remainder of your life. Provide a DNA sample as required by law. Register as a predatory offender as required by law.
Here are times dirty cops reacted to unexpected prison sentences. Let's begin with the court sentencing of former Oklahoma City police officer Daniel Holtzclaw. During the reading of the jury's verdicts on 36 counts against him, Daniel erupted in tears and regret upon learning he had been sentenced to 8 years for the first count. As the additional counts were read, his emotional breakdown deepened even more.
All right, the verdict seemed to be in proper order. This is in the District Court of Oklahoma County, State of Oklahoma, the State of Oklahoma versus Daniel K. Holtzclaw, case number CF 2014-5869. Verdict, count 1, sexual battery. We, the jury, impaneled and sworn in the above entitled cause, do upon our oaths find as follows. Defendant is guilty of the crime of sexual battery and set punishment at 8 years. Count 2, procuring lewd exhibition. Not guilty of the crime of procuring lewd exhibition. Count 3, burglary in the first degree. Defendant is not guilty of the crime of burglary in the first degree, nor lesser included. Count 4, procuring lewd exhibition. Defendant is guilty of the crime of procuring lewd exhibition and punishment is set at 5 years. Count 5, procuring lewd exhibition. Defendant is guilty of the crime of procuring lewd exhibition and punishment is set at 5 years. Count 6, defendant is not guilty of the crime of stalking. Count 7, defendant is not guilty of the crime of sexual battery. Count 8, defendant is guilty of the crime of forcible oral sodomy and punishment is set at 20 years. Count 9, rape in the first degree. Defendant is not guilty of the crime of rape in the first degree. Count 10, forcible oral sodomy. Defendant is guilty of the crime of forcible oral sodomy and punishment is set at 16 years. Count 11, rape in the first degree. Defendant is guilty of the crime of rape in the first degree and punishment is set at 30 years. Count 12, forcible oral sodomy. Defendant is not guilty of the crime of forcible oral sodomy. Count 13, sexual battery. Defendant is guilty of the crime of sexual battery and punishment is set at 8 years. Count 14, sexual battery. Defendant is guilty of the crime of sexual battery and punishment is set at 8 years. Count 15, procuring lewd exhibition. Defendant is guilty of the crime of procuring lewd exhibition and punishment is set at 5 years. Count 16, forcible oral sodomy. Defendant is guilty of the crime of forcible oral sodomy and punishment is set at 16 years. Count 17, forcible oral sodomy. Defendant is not guilty of the crime of forcible oral sodomy. Count 18, procuring lewd exhibition. Defendant is not guilty of the crime of procuring lewd exhibition. Count 19, procuring lewd exhibition. Defendant is not guilty of the crime of procuring lewd exhibition. Count 20, rape in the first degree. Defendant is not guilty of the crime of rape in the first degree. Count 21, sexual battery. Defendant is not guilty of the crime of sexual battery. Count 22, sexual battery. Defendant is not guilty of the crime of sexual battery. Count 23, sexual battery. Defendant is not guilty of the crime of sexual battery. Count 24, forcible oral sodomy. Defendant is not guilty of the crime of forcible oral sodomy. Count 25, rape in the second degree by instrumentation. Defendant is not guilty of the crime of rape in the second degree. Count 26, indecent exposure. Defendant is not guilty of the crime of indecent exposure. Count 27, forcible oral sodomy. Defendant is guilty of the crime of forcible oral sodomy and punishment is set at 16 years. Count 28, rape in the first degree. Defendant is guilty of the crime of rape in the first degree, and punishment is set at 30 years. Count 29, rape in the first degree. Defendant is guilty of the crime of rape in the first degree, and punishment is set at 30 years. Count 30, sexual battery. Defendant is guilty of the crime of sexual battery, and punishment is set at 8 years. Count 31, rape in the second degree by instrumentation. Defendant is guilty of the crime of rape in the second degree, and punishment is set at 12 years. Count 32, rape in the first degree. Defendant is guilty of the crime of rape in the first degree, and punishment is set at 30 years. Count 33, sexual battery. Defendant is guilty of the crime of sexual battery, and punishment is set at 8 years. Count 34, sexual battery. Defendant is guilty of the crime of sexual battery, and punishment is set at 8 years. Count 35, defendant procuring lewd exhibition. Defendant is not guilty of the crime of procuring lewd exhibition. Count 36, procuring lewd exhibition. Defendant is not guilty of the crime of procuring lewd exhibition. Let me ask the jury, is this your verdict, so say you all? Yes. All right. Counsel, would you like to examine the verdict forms?
Not to say no. No, Your Honor.
All right. Mr. Holtzclaw, if you and your attorneys just come forward. Mr. Holtzclaw, this jury finds you guilty of the various counts. You will be remanded to the custody of the Oklahoma County Sheriff for formal sentencing set January 21st, 2016 at 10 o'clock a.m.
Your Honor, I'd ask to poll the jury.
All right, if you have a seat.
On June 25, 2021, justice was served to former Minneapolis police officer Derek Chauvin for the killing of George Floyd at the Hennepin County Government Center in Minneapolis, Minnesota. This court footage captured Chauvin's remorseless reaction after being sentenced to 22.5 years in prison.
I wanted to thank everybody for being here and for providing the input you did. Not just the people who were in the courtroom here, but also those who provided written statements, both from the Floyd family and the defendant's family. I've read all the impact statements that were submitted earlier and listened carefully to all the input here today. And it is truly appreciated that you took the time to stay with this case and to provide me with input. I have reviewed the pre-sentence investigation and carefully considered all the facts of the case and the law, but my comments are actually going to be very brief, because most of it's going to be in writing. I have a 22-page memorandum that is going to be attached to the sentencing order. And why am I doing it in writing? To emphasize the fact that determining the appropriate sentence in any case, and in this case, is a legal analysis. It's applying the rule of law to the facts of an individual and specific case. And that is why, as opposed to trying to being profound here on the record, I prefer that you read the legal analysis that explains how I determined the sentence in this case. What the case is, or what the sentence is not based on, is emotion or sympathy. But at the same time, I want to acknowledge the deep and tremendous pain that all the families are feeling, especially the Floyd family. You have our sympathies. And I acknowledge and hear the pain that you are feeling. I acknowledge the pain not only of those in this courtroom, but the Floyd family who are outside this courtroom and other members of the community. It has been painful throughout Hennepin County, throughout the state of Minnesota, and even the country. But most importantly, we need to recognize the pain of the Floyd family. I'm not going to attempt to be profound or clever because it's not the appropriate time. I'm not basing my sentence also on public opinion. I am not basing it on any attempt to send any messages. A trial court judge, the job of a trial court judge is to apply the law to specific facts and to deal with individual cases. And so, Mr. Chauvin, as to count 1, based on the verdict of the jury finding you guilty of unintentional second-degree murder while committing a felony under Minnesota Statute 609.19 subdivision 2 paren 1, it is the judgment of the court that you now stand convicted of that offense. Pursuant to Minnesota Statute section 609.04, counts 2 and 3 will remain unadjudicated as they are lesser offenses of count 1. As sentenced for count 1, the court commits you to the custody of the Commissioner of Corrections for a period of 270 months. That's 270. That is a 10-year addition to the presumptive sentence of 150 months. This is based on your abuse of a position of trust and authority, and also the particular cruelty shown to George Floyd. You are granted credit for 199 days already served. Pay the mandatory surcharge of $78 to be paid from prison wages. You're prohibited from possessing firearms, ammunition, or explosives for the remainder of your life. Provide a DNA sample as required by law. Register as a predatory offender as required by law. And then you will receive a copy of the order and also the attached memorandum explaining the court's analysis. Anything further from the state?
If this needs to be said, we just ask that it be executed forthwith.
Defendant is remanded to the custody of the sheriff to be transported back to the DOC or whichever custody is currently holding him. Anything for the defense?
No, Your Honor.
All right. Thank you. We are adjourned.
Chauvin was also sentenced to 21 years in federal prison for violating George Floyd's civil rights, with the sentences to be served concurrently. But unlike Chauvin's reaction, the officer in this next case had a much more emotional response to his sentencing. On March 24th, 2021, former Pike County Sheriff Charles Reeder was sentenced in Pike County, Ohio, under allegations of theft and tampering with evidence. During the court hearing, Reeder addressed the court expressing remorse for his actions. Here's how the court hearing proceeded.
I stand here before you today to take accountability for my actions. As a sheriff of Ohio, I shed, I shed bad light on the office of sheriff. I can only ask that my staff, their families, the community, and my family who is here today will forgive me for the undue stress I caused them. For this, I am terribly sorry. I stood in this court on September 24th and pled guilty to the charges against me, to accept responsibility for my conduct. That day, within minutes, everything that I'd worked for professionally and honorably for 25 years was stripped of me, with nobody to blame but myself.
But you pled guilty.
I did, ma'am. Yes, Your Honor. And you're asking me, and I'm giving you the explanation. And I have paid the restitution.
I understand you've given, yes, your attorney the
But
full
that particular case,
restitution that was owing in excess of $4,000.
$4,850, Your Honor.
That's been done today. All right, I want to go back to, all right. In the PSI, the pre-sentence investigation, it indicates what you're saying here as to why you claim you used the money for various charitable community things. And then, but the PSI officer notes that there's no documentation that you used it for those things.
Right, I did not document those
Okay,
things.
now, I want to ask you about this. All right, that's your statement, what you say you used the money for, and, okay, that's on record. But I do want to ask you some other things here. Okay, the majority of the acts in this indictment took place between June 2017 and July of 2008. June 2017 and September 2017. Okay. The state obviously alleges in their brief that, particularly since you do not have any documentation of that you use this quote for charitable purposes, they secured your bank records and credit card records and all of that. And it indicates, did you lose $3,000 gambling at the Scioto Downs Racino between June 2017 and September 2017?
Yes, not by myself. They have cards. And of course, again, Your Honor, I've pled guilty to this. But they have cards that you put in a machine. I can have a card in my name, and I can have a card in my name that my wife possesses. So I can be at one machine and she can be at the other. And the money that she spends and the money that I spend, they count on the same card and calculate the money as one. Now, the state has my financial records. They will see that when we are at those casinos, and I have not been to one since and will never be at one again, that the money was taken, that our debit card was put in a machine and the money was taken from our checking account.
Well, obviously, that doesn't answer the question, where did the money in the checking account come from, but no.
At that time, I was making the salary of the sheriff and my wife was making approximately $2,500
Just asking the question here, that's all.
a pay.
Okay.
Reeder was subsequently sentenced to 3 years in prison. But this isn't the last time dirty cops reacted to the consequences of their actions in court, as we see in this next case. On January 25th, 2016, former Brimfield Police Chief David A. Oliver was sentenced in Portage County, Ohio, after pleading no contest to 4 misdemeanor charges: assault, attempted theft in office, unauthorized use of property, and unlawful restraint. Here's the court cam recording of his sentencing.
He's waiving his right to be indicted. Is that correct, Mr. Pierce?
Judge, that is correct. Mr. Oliver has executed a waiver of presentation to the grand jury, waiving his right to be indicted and having this matter considered by the grand jury. He has also, Judge, executed a waiver of trial by jury form, which I don't think the court has, but that's been executed. I'll hand it to your favor.
Thank you. Mr. Farrell, it's my understanding that you have been assigned as a special prosecutor in this matter, and that you did present this matter to a special grand jury. Is that correct?
I have been assigned as special prosecutor, Your Honor. I did not present the matter to a grand jury. The parties agreed, and I filed the bill of information this morning.
That's your understanding as well, Mr. Pierce?
That is.
It's my understanding that the defendant is going to enter a no contest plea with the stipulation to a finding of fact. Is that correct?
Yes, Your Honor.
That's correct.
And that the counts would be count 1, attempted theft in office, misdemeanor of the first degree; count 2, simple assault, misdemeanor of the first degree; count 3, unlawful restraint, misdemeanor of the third degree; and count 4, unauthorized use of property, misdemeanor of the first degree. Is that correct?
Yes, Your Honor.
Yes, Your Honor.
Of the Assistant Attorney General in sentencing the defendant with a proviso of probation, just based on what she felt was appropriate and what the attorneys agreed to. I hope this never happens again to anyone else. I hope no one else comes forward. That would be a huge letdown to everyone in law enforcement. On the attempted theft in office, misdemeanor of the first degree, I'm going to sentence the defendant to 180 days in Portage County Jail. On the simple assault, misdemeanor of the first degree, I'm going to sentence the defendant to 180 days in Portage County Jail. On the unlawful restraint, misdemeanor of the third degree, I am going to sentence the defendant to 60 days in Portage County Jail. On the unauthorized use of property, misdemeanor of the first degree, I am going to sentence the defendant to 180 days in jail. Those sentences will run concurrent to one another. I'm also going to assess the defendant a $1,000 fine and court costs. I will suspend the balance of the jail and $700 of the fine on the following conditions. First, you will be placed on basic probation here in Portage County for a period of 24 months. Second, you will pay your court costs and fines within 24 months. If you cannot pay, I will allow you to do community work service of up to 40 hours a week at $10 per hour until paid in full. Your court costs are currently $121, so to work this off, you have to do around 42 community work service hours. You will pay restitution of $1,304 in 24 months through the Adult Probation Department here in Portage County to the victim, Brimfield Police Department. You will be persona non grata at the Brimfield Police Department, and you will have absolutely no contact whatsoever, directly or indirectly, with the victim in this matter. Lastly, you will surrender your OPATA certificate under Section 109.77 of the Ohio Revised Code. It's my understanding at this time you don't have the physical certificate, but you are surrendering your right to be a peace officer in the state of Ohio. Do you understand that, sir?
Yes, ma'am.
So if you violate any of these terms or conditions, I will impose the original jail sentence on each count to run consecutive to one another. Do you understand that?
Yes, ma'am.
Anything else at this time, Mr. Pierce?
No, Your Honor, thank you.
Anything else, Ms. Tomorrow?
Not from the state, thank you.
You'll need to go over to the Adult Probation Department today and sign up with the Probation Department.
Thank you.
Thank you. All right.
Judge Lori Pittman sentenced Oliver to 2 years of probation, ordered him to surrender his peace officer certification, and imposed a $1,000 fine. Additionally, Oliver was required to pay $1,304 in restitution to the Brimfield Police Department. The charges stemmed from incidents between September 2013 and April 2014 involving allegations of misconduct by Oliver against a female officer, Crystal Casterline. These allegations led to a year-long investigation by the Ohio Bureau of Criminal Investigation. As a result of his conviction, Oliver is barred from serving as a police officer in Ohio. But if you thought this was the last time a dirty cop reacted to facing justice, then you definitely need to see the court sentencing of this officer in the next case. On February 2, 2016, former Inkster, Michigan police officer William Melendez was sentenced by Judge Vonda Evans for the assault of Floyd Dent, an unarmed black man. Melendez had been convicted of 2 felonies: misconduct in office and assault with intent to do great bodily harm, less than murder. During the sentencing, Judge Evans delivered a powerful statement, stressing the severity of Melendez's actions and the breach of public trust. Here's how the court proceedings unfolded, capturing Melendez's reactions as he faced justice.
Of January 28, 2015, where his life changed forever. He was stopped by the defendant, a then Inkster police officer, and his partner, Officer Zelenuski. Mr. Dent was stopped for a minor traffic offense and ordered out of his vehicle. With his hands extended out of his driver's window, he was grabbed out, thrown to the ground, and struck 16 times in the head by the defendant. In his attempt to arrest him, he was thrown onto a window shield of a patrol car, bleeding profusely from a head injury. The responding police officers arrived as the defendant is wrestling the defendant to the ground. Mr. Dent was struck, kicked, and tased while on the ground by what appeared to be a group of angry, anxious police officers that celebrated after the defendant was beaten and cuffed The video in the car shows the police officers fist bumping as a celebratory act of bravery by the defendant and his cohorts. But the one image that struck out to the court was looking at Mr. Dent in his cell, shaking his head. In disbelief of what had occurred to him. If his conduct was indicative of what he was thinking, I would have thought this: what crime did I commit? Being a black man in a Cadillac, stopped for a minor traffic offense by a group of racist police officers. The man chosen for your game was Floyd Dent, a black man. The game went like this. Let's follow a car in a known drug area, and based on your years of training experience, you knew that the motorist would likely be a black person, no license, armed with a gun or drugs in a vehicle. Upon stopping Mr. Dent, you knew, and upon stopping Mr. Dent, who was dead wrong for driving with no license, or license suspended, running stop signs, and weaving in and out of the back street, which the court saw in the video. You and your sidekick, auxiliary police officer Zelenowski, caught your prey. Upon being stopped, Mr. Dent put his hands out of the driver's window in plain view. Your partner and you pulled him out. When he didn't move fast enough for you, you refer to it as resisting. I call it bowing down to your command. You utilized your dirty, hairy tactics and used excessive force to arrest him. Your job was twofold: investigate the situation, be a positive example to Officer Zelenowski. When your posse arrived, they joined you in the takedown, kicking and tasing and ultimately throwing Mr. Dent into a windshield of a police car with a dash cam, which I refer to as the eye of justice. After weighing the allegations in this particular matter and looking at all the circumstances, including what you've done and who the person I really believe that you are, I'm going to commit you to the Michigan Department of Corrections as to count 1 for no less than 13 months, no more than 10 years. As to count 2, I'm going to give you 90 days credit for time served and close it out. The court's going to give you 85 days for credit. You have 42 days to appeal my decision. That concludes this matter. Thank you.
Judge Evans ultimately sentenced Melendez to a minimum of 13 months and a maximum of 10 years in prison. Don't forget to subscribe to the channel for more content like this. Thanks for watching.